you have up to 15 minutes to present your argument. The arguments are being recorded, so please stay behind the podium and keep your voice up. You should not use the names of children or minors or victims during your argument. You can refer to folks with their initials. You'll note that I used initials when I introduced the court case. And we have read your briefs and we're ready to proceed when you are, so just let me know when you want to go.
Thank you, Your Honor. I am ready.
Okay, very well.
May it please the court. My name is Christopher Chimerius, and I represent the appellant in this matter. The trial court erred in two ways. First, by granting appellees a petition for domestic violence protection order, finding that the appellee met his burden of showing by preponderance of the evidence that the appellee is in danger of domestic violence. And secondly, the trial court abused its discretion by upholding the magistrate's decision determining the appellee should be granted a domestic violence civil protection order. Your Honors, the fact pattern in this case is as follows. There was a disagreement between the father and son. They were estranged. They had not spoken to each other since 2017. On the date in question, the appellee was in his former neighborhood where the appellant lives. The appellant crossed the street after seeing appellee there to ask him why he was cutting a client's shrubs. There was a disagreement as to what happened thereafter. The only independent witness is the appellee's mother / appellant's wife, who witnessed the entire action. Your Honors, the appellant only went up to the appellee to ask him what was going on. He did not strike him. Your Honors, appellee's story of the factual pattern of what happened increased from every time he told it. It went from his father put his hands on his son's back with force. Then he shoved a fist into my back. Then, during questioning at the DVCPO, the magistrate inquired, with albeit some leading questions, asked him if he thrust with a fist into his back. Did he hit him, and then did he strike him? Your Honors, I appreciate the fact that the trier of fact is the person who has the most direct answer as to the factual scenario, is the best trier of fact. However, I would like to point out that on the date in question, the police came to the scene. They interviewed the appellant. They followed the appellant. They found the appellant. They interviewed the appellant as to the facts and the scenario of what happened that day. No charges were filed. I think that's very important here in that there was a trier of fact, in a sense, in that the police were a trier of fact. It did not have to go beyond a reasonable doubt. They did not have to go to a preponderance of the evidence. It was simply an investigation. The investigation bore out no charges. My client then filed a potential DVCPO against appellee in Cuyahoga County. Appellee was served of it. He then filed, my client dismissed. Onward we go with this matter. Your Honors, I think the greatest further admission that appellee was not in fear of his safety for any sort of domestic violence, in that once the ex parte order was in place, he went back to the neighborhood. He put himself back into the realm of potential contact, a situation whereby appellant could see appellee potentially. He put him back in the only place that he had really seen his father since 2007. They don't see each other at any sort of family gatherings. They don't talk on the phone. Granted, all of these are unfortunate circumstances, but they're the truth. They don't talk on the phone. They don't interact. One lives about 20 minutes from the other. The only point of contact, and the only place where, if someone was truly afraid of some sort of domestic violence happening, would be in this neighborhood, and appellee put himself back in that zone. think that goes to the fact that he was not in fear of his safety. He was not in fear of any sort of further domestic violence acts happening. If there was a threat of force or imminent physical harm, it would have happened in that neighborhood. Again, he returned. Your Honors, I appreciate the fact that DVCPOs are extraordinarily important mechanisms that are used in the community today. I appreciate the fact that the standard of proof is lower than criminal matters. However, I would like to focus in on, again, this is an estranged relationship. They don't get on, the father and son. They are never going to get on, seemingly, unfortunately, in the future. There is a question of fact as to what sort of contact was made on the date in question. Again, FLE, every time he talked about it, it got more and more serious. When the magistrate questioned him, it got more and more direct. However, again, I would like to point out that law enforcement saw no issue with it. I was never noticed that a report was made to a prosecutor, the prosecutor investigated it, they never ran it up the chain of command. The only thing that ever happened was, again, my client filed with DVCPO, his head pulled off, he dismissed. Appellee then filed one in retribution, and then his was granted. So again, Your Honor, based on the foregoing, the decision of the lower court should be overturned, because the appellee failed to meet his burden of proof beyond a preponderance of the evidence that he is in danger of physical violence or domestic violence. Furthermore, the trial court abused its discretion by upholding the magistrate's decision granting the DVCPO. Therefore, we ask the decision be reversed. Thank you.
Thank you very much, counsel. The court will take the matter under advisement and issue a decision in due course. That decision will be mailed to you and the other party on the day that it is released by the clerk of courts. The opinions are also put